So, what should doctors consider when making gifts to their children at the time of death? Hi, I'm Claire at the Yanowitz law firm, and we've been helping physicians plan their estate plans now for over 3 decades. And in this video today, we're going to talk about different ways you can pass assets to your children. Now, oftentimes, children of physicians are in a situation where they may inherit significant amounts of money. And as a result, there is a more compelling reason that the children should receive their inheritance in a way that is protected. So there's different ways you can give assets to your family, and I'm going to talk to you about them in this film. So the first way to give assets to your children is not in a very protected way. It's in a simple way, but not protected. And that is, we call it direct heir, where you just give it outright to your children. They can do whatever they want with it and spend it however they want. And if in the future they get sued, get divorced, maybe file for bankruptcy, someone else can take these assets away from them. The second way that children might inherit is also set up for someone who maybe isn't inheriting as much money and is younger. The first way, the direct heir, that is not possible for minors. Minors cannot inherit directly. It creates all sorts of problems and court involvement. So you don't want that. So the second way that minors could inherit, we call growth guard. And in growth guard, the assets are put into a trust until the children are older. And then when they get older, the trust kind of releases at times. And oftentimes, this is helpful for children that are inheriting more of a modest amount of money. And they need training wheels on that inheritance until they're a bit older. Someone can inherit outright when they're age 18, but most 18-year-olds are not ready to take on an inheritance of even a couple $100,000. They may spend it unwisely. They may drop out of school and be disincentivized to get a responsible job and move along in life. So oftentimes people want to have that money sheltered until they're a bit older. And then in the future, the trust implodes, basically. It doesn't exist in the future when they're older. And oftentimes I see that people want these trusts to terminate sometime in the late 20s to mid 30s, when they think that probably their children's feet are going to be on the ground and they're going to be more adept at managing money at that point. Before that time, the children can get at the money, but the trustee is going to be the one in charge of giving them the funds and determining, yes, we should use some of your inheritance to go to college or graduate school or buy this modest house, your starter home. So the trustee can determine this is a good use of your inheritance. The third way, which is probably the most common way we find that physicians give assets to their children, is in a trust that can potentially last for the child's entire lifetime. And the reason why so many physicians pick this is because their children are inheriting significant assets and they want to ensure that in the future, if something bad happens, they get a divorce, get sued, or maybe they become a business owner, or they have some sort of liability in their profession and they're getting sued, or they're even filing for bankruptcy, that this asset is preserved for their child's enjoyment in the future. A lifetime trust can provide that protection in a lot of states. With a lifetime trust, the trust never automatically terminates in the future. We call this type of plan a legacy safe plan in our firm. And so the trust doesn't terminate ever in the future automatically, unlike the growth guard where it's set to determine, it has its end date when kid hits 35. Whereas with the legacy safe, it can go on in perpetuity during the kid's life. And what we can do is we can create like a training wheels situation with this, where if the child is inheriting when they're younger and they aren't ready to manage their own money, you can have another person be trustee of these funds of the trust. And then when the child is older, they can become co-trustee with that trustee. So they have a seat at the table. They can give advice on how they want things invested. And then When they're even older than that, maybe you give them the opportunity to determine who their co-trustee is. An example of how this could play out. Let's say we have Joey. Joey's a minor, and so his aunt Sally is trustee of his trust. And then Joey gets to be older. He hits 25, and Joey becomes co-trustee with Sally. So he's able to make investment decisions with Sally and has a spot at the table, but Sally is in charge of distributing to Joey. And then Joey hits age 35, and Sally's getting older and is no longer suited to serving in this role. So Joey decides to remove her and replace it with his own co-trustee. So he's in charge of that co-trustee role. So that's one way you can set it up. Or alternatively, when you say Joey hits 35 or 30 or whatever old age you think your children are going to be mature, you say at that age, Joey can be sole trustee of his own trust. And he is in charge of financial management and distributing assets and all of that. And in some states, a child being sole trustee of their trust can provide enhanced asset protection in the event Joey gets divorced and sued. In other states, it's important to require a co-trustee of the trust, in which case we can require a co-trustee, but when Joey's of age, he's in charge of who that co-trustee is. So if he doesn't like that Sally's not distributing him assets, when he feels he should be getting distributed assets, he can effectively fire her and pick a co-trustee that will do what he tells them to. Thanks so much for listening today. If you want to learn more about estate planning and asset protection, feel free to hit the subscribe button so you can learn more about this topic and be notified when we release new videos to our channel.